Thanks very much. In the context of what has recently happened with the Treasury and the Department of Justice and the setting up of the $1.8 billion cop beaters slush fund, the very week after Police Week here in Washington, I thought that Mr. Schwartz's comments about the merit of standing indicated quite clearly why that self-dealing cop beaters slush fund is so deeply, deeply problematic, without even going to the Trump family tax amnesty that it provided with literally one lawyer's signature on the document. Usually, if there's a contested matter, there are two parties. In this case, one lawyer signed it. And we don't know whether he signed it as acting attorney general or as Trump's personal lawyer, but we do know that it created a $1 billion cop beaters slush fund, and we do know that it gave the Trump family and associated businesses amnesty from any tax mischief or fraud that they may have committed. And it's really hard to see how there was any real case or controversy in that little scheme. But I also want to note that Mr. Schwartz is here without blue slips from the senators from the Second Circuit state. And just to remind everybody, I warned when we got rid of the circuit court blue slip that this was going to be unpleasant, and I've had colleagues on the other side express their dissatisfaction when they were ignored for blue slips. So here we are again. I don't want to hear a lot of complaining about blue slips in the future after we go through these exercises and ignore senators' rights to have a blue slip. But I want to talk about something different that just happened fairly recently. In Wyoming, a U.S. attorney was sanctioned by the federal court. 9 criminal indictments were thrown out as a result of improper conversations with grand jurors by the U.S. attorney. He called the defendants murderers, even though there were not homicide charges in the proposed indictment. He called them bad guys, not run-of-the-mill criminals. He handed out his business cards to the grand jurors and invited them to get in touch with him privately. A 1L could do issue spotting in that fact pattern and see massive, massive error and misconduct. It was challenged by the lawyers for the defendants who said this is not an isolated lapse. It has metastasized into systemic institutional failure, and the taint is widespread and continuous. And guess what? The court agreed. The court said that the cumulative effect of many known instances of misconduct, implying that there may be further unknown instances of misconduct, justified dismissing the complaints. The court found that none of the U.S. attorney's excuses carry water when viewed, I'm quoting here, when viewed against the volume and the flagrancy of the misconduct, end quote. And then concluded that this U.S. attorney had abused his special position of trust. Here's what's interesting about that order and that U.S. attorney. That order was filed on May 15th of this year. 3 days later, on May 18th, that U.S. attorney, who'd been voted on in this committee, was slipped into the big en bloc list for confirmation without anyone in the Senate being told about that May 15th order regarding his professional misconduct. And I gotta say, I don't think that's the way this committee should operate. I think if there's an order from the federal court challenging the integrity and the competence of a United States attorney who is pending before the United States Senate, and we're not informed about that order for 3 days, and we don't even get an individual vote on that nominee. Instead, he's buried into the en bloc group, which I think was 49 different confirmations that day. That's not what the Senate is supposed to be. This guy should not be a U.S. attorney. And his confirmation should certainly not have been slipped in without disclosure of this order into an en bloc confirmation vote. I think the Senate was misled by that, and my time has expired.
What stands out in this exchange is the argument that institutional accountability cannot selectively disappear when politically connected figures or nominees are involved. From the Democratic perspective being expressed here, the concern is not simply about one controversial legal decision or one prosecutor's misconduct, but about a broader pattern in which oversight mechanisms appear weakened when they intersect with political power. The criticism surrounding the so-called slush fund is framed as part of a larger concern about transparency and conflicts of interest within government decision-making. From this viewpoint, the issue is not just the legal structure itself, but the perception that political allies and powerful individuals may be receiving protections or advantages that ordinary Americans would never receive. The repeated emphasis on signatures, undisclosed arrangements, and alleged immunity reflects a fear that public institutions are being used to shield insiders, rather than uphold equal accountability under the law. As the focus shifts to the Wyoming case, the discussion becomes more centered on prosecutorial ethics and Senate responsibility. The allegations described against the U.S. attorney are portrayed as serious violations of professional conduct, not minor procedural errors, but actions that allegedly undermine the integrity of the justice process itself. From the Democratic framing, the fact that multiple indictments were dismissed by a federal court strengthens the argument that this was not an isolated lapse in judgment, but evidence of systemic misconduct severe enough to compromise public trust. What intensifies the criticism is the timeline being highlighted. The suggestion that a nominee facing a recent judicial rebuke could still move quietly through confirmation procedures without full Senate awareness is being presented as a failure of transparency. From this perspective, senators cannot meaningfully exercise oversight if critical information is withheld or buried within broader procedural votes. There is also a deeper institutional concern running through the exchange. Whether Senate norms, disclosure practices, and ethical safeguards are being gradually weakened in pursuit of political expediency. The Democratic argument here is that procedural shortcuts and selective disclosure erode confidence not only in individual nominees, but in the credibility of the confirmation process itself. Ultimately, this exchange reflects a broader Democratic critique about power and accountability in government. The central message being conveyed is that justice systems, ethics offices, and Senate oversight procedures lose legitimacy when rules appear flexible for politically connected individuals, while remaining rigid for everyone else. From that viewpoint, the issue is not merely partisan disagreement. It is whether public institutions are still functioning with transparency, integrity, and equal standards of accountability.